Hello and welcome. You're watching this special broadcast to deal with what is big breaking news, and that is the Supreme Court's judgment in the Electoral Bonds case. It is a unanimous judgment that has come through, and one of the statements essentially underlines that judgment. What the CJI said not long back is that the Electoral Bond Scheme and relevant amendments to the Representation of the People Act and the Income Tax Act mandating non-disclosure of particulars on political contributions through electoral bonds is unconstitutional. The scheme itself has been called unconstitutional by the Supreme Court, but there's more besides that. There are directions that the Supreme Court has set out. It has first and foremost said that issuing banks shall forthwith stop the issue of electoral bonds, and the State Bank of India will now have to furnish the details of donations through electoral bonds and the details of the political parties which received the contributions. They will have to send that in by the 31st of March 2024 to the Election Commission of India, and the Election Commission of India will have to submit it to the website by that date. This is all very significant. There are a few more addendums to that list of directions that the Supreme Court and the Chief Justice of India laid out. Among them, of course, is that if there are any valid electoral bonds over the with a 15-day validity that have not yet been encashed, then those electoral bonds will have to be returned and will have to go back to the issuer. Tamanna is joining in to put some of this in perspective. Tamanna, beyond just, of course, this landmark ruling, there are implications ahead of what will be a very crucial election period with the general election coming up.
It's ringing for 3 minutes.
Tamanna, if you can hear me, I've just laid out what the Supreme Court has stated in its judgment on the Electoral Bonds case. Okay, we've lost Tamanna. What I'm going to do in the interim is try and get you. Okay, so we've got Sanjay Hegde, who's a senior advocate at the Supreme Court, joining in. Mr. Hegde, thanks so much for joining in. I have just laid out what the Chief Justice of India said about the Electoral Bond Scheme, the fact that it is unconstitutional, and also the directions. Can you help us understand, in brief, what you made of the explanation for that judgment?
Explanation for the judgment is that voters have a right to know, number one. Number two, that contributors do not have a right of privacy in regard to financial contributions which could be part of a quid pro quo transaction. The court has held all these amendments to the various acts, including the amendment to the Companies Act, as manifestly arbitrary. Therefore, what the court has said is that all information with regard to electoral bonds which have been issued since the filing of the petitions will have to be disclosed. Can you hear me?
Yes, I can hear you. Please go ahead.
So the details will have to be disclosed to the Election Commission. The Election Commission in turn will have to put it on a website so that the country can exactly know which electoral bonds were purchased by whom and given to whom at which stage. So this is historic. This also means that money or big money cannot influence elections in a totally opaque manner.
And also the point that was made, Mr. Hegde, about the initial ambit of the electoral bond scheme, which was ostensibly to prevent the use or to curb the use of black money.
Yes.
And the Supreme Court has weighed in on that as well.
Yes, the court says that this instrument is not proportional to the needs which are laid out. The court says that there are alternative means of financing which would be proportional. If you essentially allow big money to be donated anonymously, irrespective of whether the company is making a profit or not, and the transactions are known only to the SBI and nobody else, then there is a problem, and the court has held that these things are unconstitutional.
Mr. Hegde, from a legal standpoint, now perhaps the sticking point is going to be the names and the details of the contributions that have been made through the scheme, which will now have to be disclosed. Does the government have any recourse legally to prevent that?
Well, I do expect the government to try the usual measures of a review petition and all that. But it would surprise me very much if any wiggle room was left. It was a very lengthy judgment which has been pronounced. All aspects have been taken into account. I do not also think that the country and the institutions will like any further skullduggery at this point of time. I'm basically looking at the Election Commission immediately summoning the information from the SBI. And if the SBI were to use an Americanism, play cute, I do not think it would be greatly appreciated.
Understood. Mr. Hegde, thanks so much for joining and giving us that perspective. Tamanna is also with us. Tamanna,